What's being abused is the process, the court process, which is being abused to take one parent out of the life of the child, turning them into a non-entity or minimizing one. And the court process, we have to pick a winner and a loser. Right now, the winner wins big, the loser loses big. What this does is take away the big win, big loss. We have two loving, fit parents. The children have a right to have them in their lives.
Oftentimes, when there is no shared parenting and there is a contentious divorce, there is visitation interference that occurs. And when there is less time and there's more of an opportunity for alienation to occur, alienation being child psychological abuse, as it was just recently described in the new DSM-5 in April of 2013, DSM-5 being the Diagnostic Statistic Manual for Mental Health Professionals.
Terribly adversarial. But the real best interest of children, if you look at it from a psychological perspective or social science perspective, is that children are benefited far more from equal time with their parents than they are from whatever the results of an adversarial decision are. The best interests of children are to be able to have a relationship with each parent that is free of any kind of poisonous intrusion of what happens when adversarial processes occur and they end up saying, well, this parent gets 85% of the time at some level for a child. That means that parent must be 85% better as a parent than the parent with the 15%.
% residential time per week should be ordered from the non-custodial parents. And I've got several witnesses here that will also like to give a short testimony, and then we'll answer any questions. I'd also respectfully ask for an aye vote.
So we have 25 pages of witness slips, so I will dispense with the reading of all of those witness slips.
What this bill does is it presumes both parents are fit. It creates a rebuttable presumption that allocation of not less than 35% residential time is in the child's best interest, and it provides procedures for filing of parenting plans where parenting plans aren't agreed by the parents, that the judge will help in providing a parenting plans. Now, what I read is what the bill's about, but the words I read were the exact same words that are the recommendations of the Illinois Family Law Study Committee. The Illinois Family Law Study Committee was formed by the House in 2008 to look at the laws and bring them up to date with social science. I know that the committee testified, or members of the committee testified before you on May 22nd, 2013, reinforcing these concepts. They discussed how many years that they spent looking at the social sciences to ensure that our laws were drafted based on current science. This committee consisted of lawyers, judges, representatives, and people who are experts. The custody subcommittee that helped make these recommendations, they voted on these concepts 6-0. It was unanimous. And when it went before the full Illinois Family Law Study Committee, the vote was 11-6 to make these recommendations to place in the law.
Good afternoon. My name is Danielle Gomez. I'm an attorney with the Cook County Public Guardian's Office. The Cook County Public Guardian is court-appointed at the discretion of the court to represent children as child representative in custody cases in Cook County. The majority of the case, or all of the cases that we are appointed on, tend to be very contested child custody cases. We currently represent 780 children as a child representative in child custody cases pending in Cook County, and we always average about approximately that number at any given time of children. Again, we represent children, we do not represent parents in divorce cases. We are strenuously opposed to any type of presumption in a statute related to child best interest. The current statute already provides that one goal of the act is to maximize the involvement of both parents in the lives of the child, and we think it strikes the right balance and enumerates factors to consider in a child's best interest. There is nothing in the current act that prevents parents from agreeing to a plan that works for them and works for their child that's different. There is nothing that requires a court to order something specific, and that's really what we're opposed to in this particular bill. This bill would require, if parents don't agree, that the court enter a parenting plan that requires that the children either share time with the parents or that the parent have a minimum of 35% of the child's residential parenting time. There are so many factors that go into what is in an individual child's best interest.
Majority is hereby declared passed. House Bill 1452, Representative Kelly Burke, please read the bill.
House Bill 1452, a bill for an act concerning civil law. Third reading of this House bill.
Representative Burke.
Thank you, Mr. Speaker. House Bill 1452 is a set of changes to the Illinois Marriage and Dissolution of Marriage Act. It incorporates many of the recommendations of the bipartisan Illinois Family Law Study Committee, which was created by this body in 2008. The bill makes changes to aspects of the statute, notably improvements regarding disclosures of attorney's fees. It focuses on reducing litigation by removing grounds for divorce and eliminating heartbound remedies. It helps litigation in that it provides that judges must issue decision within 60 days of closing of proofs of the case, and it sets a framework for a more interactive role with parents in determining a parenting plan for their children during their divorce case and when the case is finished. Makes important changes to the law regarding maintenance, payment of college expenses, and support for disabled children. There are many other smaller changes to the statute, but the result is a comprehensive approach to improve the legal process of divorce and provide more efficient, fair divorces while better protecting our children. The committee worked extensively with many groups, both from the law profession, government agencies, and advocates. There was a tremendous amount of back and forth and negotiation on this bill. And I thank the members of the State Bar Association, the Cook County Public Guardian, the Chicago Bar Association, and HFS and DCFS for giving us input on this and making some important improvements. We have one unresolved issue that we're going to work on with the ISBA in the Senate, but I think this bill is a big step forward and an improvement on a 30-year-old dissolution statute. I welcome any questions, and I urge an aye vote.
Mr. Sandak.
Thank you, Mr. Speaker. Will the sponsor yield?
Lady yields.
Kelly, there was a lot of discussion. We had subject matter hearing after subject matter hearing, and I know there was a very collaborative process at first, but then there were some areas of disagreement. And the one that I want to talk to you about is the 35% presumption. Is that still in the bill?
That is not in this bill. It was taken out, and it's in a separate bill.
Okay, so as this bill, and by the way, the bill is not done. There's still continued discussions, and it's your intent to work with the Senate sponsor to try and make it as agreed as possible.
Yes, we have a couple small issues and then one issue where we're in discussions. We just haven't come to an agreement on the best way to handle it, but I think that will get done in the Senate.
And do you know of any strong opponents still as we stand here today?
No, I don't.
Thank you. To the bill, Mr. Speaker, I want to commend the sponsor. It's been an arduous process. She has done a yeoman's job of moving a really difficult piece of legislation forward. I saw some hearings on this. There were strong opinions all across the board from practitioners, judges, and advocates. However, I think she's framed the issues properly. I hope to continue to work with her in the Senate, but I think this is a good bill, and I urge a yes vote.
Representative Neckrits.
Thank you, Mr. Speaker. I want to join the previous representative in thanking the sponsor for taking on this very difficult task. I hold myself responsible for putting her in charge of this with her experience in the family law area in her private sector life. There's nothing in this that's going to satisfy everybody, because for every lawyer that practices family law in this state of Illinois, there's going to be someone who thinks it ought to be done their way rather than somebody else's way. This has been a very long, difficult negotiation, a process that's involved a lot of people, and I think this bill deserves to get a positive vote today, and then we can send it over to the Senate and get their input as well, and that negotiation and that discussion will continue. But I think it's important that we say yes to something today, and then let the Senate have put their thumbprint on it as well. Thank you.
Representative Belloc.
Thank you very much, Mr. Speaker. Will the sponsor yield?
Sponsor yields.
I just thank you, Representative Burke. I know this was a lot of work over a lot of time. I just wanted to know if there was still opposition by the Illinois Family Institute or the people who had some concerns about it before.
No, they're not opposed to this bill.
Oh, thank you very much.
Those in favor of the bill will vote yes. Opposed, no. The voting is open. Have all voted who wish? Have all voted who wish? Have all voted who wish? Cross, Sullivan. Please take the record. On this question, there are 90 voting yes, 17 voting no, 3 voting present, and this bill having received the constitutional majority is hereby declared passed.